Welcome to everyone. It's great to be with you on Valentine's Day and this installment of Bond's Business in 2023 webinar. We have a great program for you today, and we are going to kick it off not with my normal COVID update because that is going to come later, but we're going to kick it off with something way more important, and that is Subha Viswanathan. Subha has been on a number of times and is an expert in all things wage and hour law related. So Subha is here to continue his series on wage and hour laws and how they impact your business. Subha, welcome.
Thanks, Adam. Today we're going to cover call-in pay, split shift pay, and spread of hours pay. These are some kind of hidden pay entitlements in the New York State Department of Labor wage orders. That can result in litigation if they're not applied properly. So we thought it'd be a good idea to just kind of review the requirements, and you all can assess whether you have any compliance issues that might need to be addressed. Next slide, please, Kathy. So let's start with the minimum wage order for miscellaneous industries and occupations. The call-in pay, the general rule is that an employee who by request or permission of the employer reports for work on any day shall be paid for at least 4 hours or the number of hours in the regularly scheduled shift, whichever is less, at the basic minimum hourly wage. So a couple of things right off the bat. The language specifically says basic minimum hourly wage. So the entitlement to the call-in pay is not at the employee's regular hourly rate. It's simply at the basic minimum hourly wage, which, as we know, in New York City and downstate is $15 an hour, and upstate is $14.20 per hour. It's also either 4 hours or the number of hours in the regularly scheduled shift. Regularly scheduled shift is actually not defined in the miscellaneous industries and occupations wage order. But what the Department of Labor looks at is the shift regular? Is it predictable? Is it something that the employee can count on a particular day of the week? For example, if the employer schedules an employee to a 3-hour shift every Tuesday, and that's just a regular part of the employee's schedule, that will be considered a regularly scheduled shift. So on that particular day, even though the employee is scheduled for 3 hours, they wouldn't be entitled to 1 hour of call and pay for that day. They would only be entitled to payment for the regularly scheduled shift. On the other hand, if the regular schedule is Monday through Friday, 8 to 5, and the employer, even if it's scheduled in advance, if the employer schedules a team meeting on Saturday morning for an hour, that will be considered not a regularly scheduled shift, and employees will be entitled to the call-in pay. The phrase request or permission of the employer is also a little bit vague, but the Department of Labor has clarified that permission doesn't mean permission to leave early. So if an employee leaves early because there's a personal emergency or illness and gets permission to leave, that will be considered a voluntary departure on the part of the employee, and the employee won't be entitled to the call-in pay. So this really just contemplates situations where it's the employer who's either scheduling an employee for an unusual shift of less than 4 hours, or is calling in an employee or sending an employee home without working a full 4-hour shift. Next slide, please, Kathy. So it's hard to talk about these issues sometimes without a little bit of math. So I hope you're ready for some computations. The basic minimum hourly wage is computed on a weekly basis. It's not computed on a per shift basis or a per day basis under the minimum miscellaneous industries and occupations wage order. So it's probably easier illustrated with an example. So let's assume we have an employee who works in New York City, and the employer's regular hourly rate is $18 per hour. So as you know, minimum rate is 15. This employee is making $3 per hour more than the minimum. Let's assume the employee's regular shift is Monday through Friday, 8:30 a.m. to 5 p.m. with a 30-minute unpaid meal period each day. So It's a regular 40-hour work week. The employee is called into work on Saturday from 8:30 a.m. to 10:30 a.m. The employee is paid the regular plus overtime compensation in the amount of $774 for the week. So we got the $18 for the first 40, time and a half, 27 times the 2 hours that they worked on Saturday is the $774. So what about the call-in pay for requiring the employee to work only 2 hours on Saturday, right? There's 2 hours that's missing. Next slide, please, Kathy. So in this particular example, there's no extra call-in pay that's owed for the work week. The employer is only legally obligated to pay the minimum wage for the first 40 hours, time and a half, the regular rate for the 2 overtime hours, plus an extra 2 hours of call-in pay at the basic minimum wage rate. So if you add all that up, the employee is actually only entitled under the minimum wage order for miscellaneous industries and occupations to a total of $684 for the work week. The employer has already exceeded the obligation by paying $774, so there's nothing more that's owed. So as we can see by these computations, the higher the regular rate is above the minimum wage, the less likely it is that call-in pay will ever become an issue, at least under the miscellaneous industries and occupations wage order. If you have employees who are making at the minimum wage or slightly above, that's where the call-in pay requirement really comes into play for those types of employees. Next slide, please, Kathy. So the hospitality industry wage order is different. If you look at the language of the hospitality wage order, that doesn't use the language basic minimum rate. It uses applicable wage rate, and it's for the lesser of 3 hours for one shift, or the number of hours in the regularly scheduled shift, 6 hours for 2 shifts totaling 6 hours or less, or again, the number of hours in the regularly scheduled shift, or 8 hours for 3 shifts totaling 8 hours or less. Next slide, please, Kathy. In this context, in the hospitality industry wage order, regularly scheduled shift is actually defined. So we can kind of use this definition as guidance for the miscellaneous industries and occupations, but it's really the same concept. It's a fixed repeating shift that an employee normally works on the same day each week. If the total hours worked or hours scheduled to work change from week to week, then there will be no regularly scheduled shift. Next slide, please, Kathy. So the applicable wage rate is defined as payment for the time of actual attendance at work, calculated at the employee's regular or overtime rate of pay, whichever is applicable. So obviously, first 40 hours in the work week, regular, above 40, the overtime rate, minus any customary and usual tip credit, and payment for the balance of the period, calculated at the basic minimum hourly rate with no tip credit subtracted. And this wage order specifically says, unlike the miscellaneous industries wage order, this specifically says that this applies to all employees, even if the regular hourly rate exceeds the minimum wage rate. Next slide, please, Kathy. So here's an example that's kind of parallel to our miscellaneous industries example, but you can see that there's going to be a different result. Suppose an employee works as a server at a New York City restaurant, and the employee's regular hourly rate is $18 per hour. I'm not including any sort of tip credit in this example because I sort of want to make it consistent with the miscellaneous industries example. The employee's regular shift is Tuesday through Saturday, 3:30 to midnight, with a 30-minute unpaid meal period. So we have a regular 40-hour work week. The employee is not ordinarily scheduled to work on Sunday, but is scheduled to assist with a lunch banquet on one Sunday for only 2 hours. The employee is paid regular plus overtime compensation, again, in the amount of that $774. So in this example, what about that call-in pay? Next slide, please, Kathy. So in this example, extra call-in pay is owed for the work week. It's not a regularly scheduled shift of 2 hours, so the 3-hour minimum pay requirement will apply. The employer in the hospitality industry is legally obligated to pay the regular rate for the first 40 hours, 1.5 times the regular rate for the 2 overtime hours, plus an extra hour of call-in pay at the basic minimum wage rate. So that $774 isn't going to be enough. The employee is going to be owed an extra $15 for that 1 hour of call-in pay for that Sunday banquet. Next slide, please, Kathy. A couple of other types of hidden pay entitlements are split shift and spread of hours pay. Under the miscellaneous industries and occupations wage order, an employee is entitled to get 1 hour of pay at the basic minimum hourly wage rate in addition to the minimum wage for any day in which the spread of hours exceeds 10, there's a split shift, or both situations occur. And this is also computed on a weekly basis. So again, the higher above minimum wage the employee's regular rate is, the less likely it's going to be that the split shift and spread of hours pay is going to result in an extra pay obligation. Next slide, please, Kathy. A split shift is any two or multiple shifts in a day where the working hours are not consecutive. An unpaid meal period of 1 hour or less is not considered an interruption in consecutive hours. Spread of hours is defined as the interval between the beginning and end of the employee's workday, and that includes unpaid meal periods as well as intervals off duty. So a couple of examples, a spread of hours could be a continuous shift from 8 a.m. to 6:30 p.m., or it could be a shift from 8 a.m. to 12 p.m., and then another shift from 2:30 p.m. to 6:30 p.m. So in that second circumstance, we have both a spread of hours exceeding 10 as well as a split shift. Next slide, please, Kathy. In the hospitality industry, on each day in which the spread of hours exceeds 10, an employee in a restaurant or an all-year hotel is entitled to 1 additional hour of pay at the basic minimum hourly rate. And again, this has a specific provision that says it applies to all employees in restaurants and all-year hotels, even if the regular hourly rate exceeds the minimum wage rate. So in this context, again, the regular rate, even if it's above the minimum wage, it doesn't matter. It still likely will result in an extra pay entitlement for the employee, regardless of the regular rate. And resort hotels are not covered by this. So employees in resort hotels do not have a spread of hours pay entitlement. Same definition of the spread of hours in this context as under the miscellaneous industries and occupations wage order. And there's no separate split shift pay requirement in the hospitality industry. So in the hospitality industry, if you have a split shift where the spread of hours doesn't exceed 10, there is not an additional pay obligation under the hospitality industry wage order. Next slide, please, Kathy. And that's it for me.
Well, Suba, thank you very much. You described them very well as hidden entitlements because these are things that, unless you're paying very close attention, you can easily mess up. So if you have any questions about these hidden entitlements, obviously, please reach out to Suba or any labor employment attorney that you work with here at Bond. I know that violating these rules can result in significant fines, penalties, and/or liability for an employer. So pay attention, and if you have questions, don't hesitate to reach out. Okay, next up we have Colin Leonard. Colin is a member in our Syracuse office who does a lot of what you see on the screen, which is collective bargaining, and he's here to talk to us a little bit about fundamentals of that process and things that you can think about as you enter it, whether you're doing it for the 10th, 20th time, or you're doing it for the first time. So Colin, thank you and welcome.
Thanks, Adam. And I'll just start off by saying this section is not going to have any math. So Suba, you did a great job working through that with us, but we're going to take a little bit of break from the math here. I really just want to talk about three fundamental aspects. There's a lot to collective bargaining, and I want to talk about those just 3 points to give you kind of an overview of this field. But I do want to start with some figures. Again, there's no math here. I'm just going to give you some numbers, but just so you know, we just had the 2022 figures come out from BLS, the Bureau of Labor Statistics, which indicates what the level of unionization is in the United States. So for 2022, that level was 10.1% of all workers in the United States were members of a union. It's just down slightly from 10.3 in 2023. That equates to about 14.3 million workers in the United States being members of a union. In the public sector, the rate is much higher. It's about 33%. 1 in 3 workers in the United States in the public sector is a member of a union. The private sector rate is approximately 6%. Well, New York, as you may know, is an entirely different story in terms of those national rates, which I just gave you. New York has the second highest rate in the United States of unionization at 20.7%. Hawaii is the only other state that's actually higher at 21.9%. Other states where you may have workplaces which have high levels of unionization: California, Washington, Oregon, Connecticut, New Jersey, Minnesota, and Michigan all have significant double-digit rates of unionization. Finally, just to give you a sense of this, if we talked about the 14.3 million workers in the United States that are members of a union, just about 30% live in just 2 states, California and New York. So we are massive in terms of relative terms about the percentage of union workers here in New York. So that's why we all deal with collective bargaining on a very significant and regular basis. So just to step back, collective bargaining right is an alternative to the employment at will rule, which we have in New York and many other states, which is an individual can decide for him or herself whether to be employed or not, and same thing for the employer. And the only thing that you can't do is separate somebody or discipline somebody because of an illegal reason, like a protected category as well. So there are 2 exceptions to that employment at will rule. One is where you have an employee who's employed to a fixed duration contract of employment. So let's say an executive or high-level employee in your organization who has a written employment contract for 1 year, 2 years, 3 years. That's an exception to the employment at will doctrine. The other exception involves collective bargaining, union employed workforces. That's another exception. So where we're talking about a union represented employer, we're talking about a fundamental change in the manner in which employees and employers interact. So in an at-will workplace, of course, what we're dealing with is each employee has the ability to negotiate for him or herself with respect to the terms and conditions of employment. And the employer likewise has that ability to directly deal with the employee. In a unionized workplace, that rule is actually gone. And what the employees have elected to do is to have a bargaining representative represent all of the employees collectively and bargain collectively on their behalf with respect to all of the terms and conditions of employment. And hence, eventually, one day get a contract that's going to apply, your collective bargaining agreement. So as I said, I just want to cover 3 basic considerations when we talk about collective bargaining. First of all, when I talk to people about it who don't know what I do, they're very often picturing a smoke-filled back room in a cafeteria somewhere and bargaining late at night or in the early hours of the morning. Those things can happen, but more often you're in a conference room, as I've found. You're in a conference room in a hotel, or you're at the manufacturer's, the employer's facility, and you're at a table with your team, your management team, which is very often made up of some certain common areas. There's always somebody from HR involved. There's very often, or I would say always, somebody involved from finance who is very critical in terms of crunching the numbers and costing out proposals that come along. And then there's very often someone from the in-house legal department that's involved as well. The fourth member of the team, and this can be a much larger team, very often is a manager in a critical work area or critical function at the facility. So that person is there to help you better understand the work, the day-to-day work that's occurring. And then my role, or the role of labor and employment attorneys at Bond, is to serve as chief spokesperson, typically. That involves presenting the proposals. And before you even get to that point, that involves working for a significant amount of time preparing the proposals that are going to be exchanged in collective bargaining. So as a chief spokesperson, you're presenting the proposals, you're doing a lot of explaining of the proposals. The other thing that people don't realize about collective bargaining is, although you're at the table for significant amounts of time, there's also quite a bit of time that's spent in caucuses. A caucus is an opportunity for each side, sometimes both sides, decide together that they need some time to talk to their team about the proposals, maybe ask each other's questions about the proposals outside of the presence of the other team. So we spend time in caucuses articulating, trying to determine what our standpoint is going to be. That's conveyed to me as the chief spokesperson, and then I come out and deliver the message. The second thing I just wanted to briefly talk about is how very important it is in collective bargaining for you to have a theme. The theme is something that you return to throughout the bargaining sessions. Your sessions, you might have 5 sessions, you might have 25 sessions of negotiations. But your theme is really a constant. It drives all of your proposals. It's something you can rely upon when you have to go back and explain your proposals to another side, to the other side. The proposal, or the theme, I should say, is there's some common ones, the ones that I've heard quite a bit. I've said some of these. The one theme might be the size of our workforce cannot be maintained at the level that it is because we've just got technology updates that are changing things. Another theme might be we really need to update the skills of our employees to allow them to address changes that we're seeing in the industry. Another theme often deals with the concept of flexibility on the part of management. We need a more flexible workforce, one that can adapt to changes. We need people to be able to have multiple skills rather than just do one type of activity. If you're a union, the skill or the themes are very often understood. I hear them very often. One of the main ones is we need a voice. They feel like they need to be heard in the workplace, and they feel that the collective bargaining agreement will give them an opportunity to say things to help impact and improve the lives of workers. Another theme that's happening very often today is the pace issue, that workers feel that they can't keep up with the pace of the workplace, either because there aren't enough workers out there or management is demanding too much of the workers. So that's often a theme that you hear. And then finally, it's one of those things that I hear quite a bit, which is we aren't going to have our jobs be outsourced or sent to a non-bargaining unit position. That kind of theme will work through many of the union's proposals. Finally, the last thing I just want to talk about in terms of collective bargaining is it is at the end really about the art of persuasion. Of course, the whole point of collective bargaining generally is to reach a contract agreement over time by exchanging proposals. But each side does come to the negotiations table with its own set of priorities. And so the spokesperson, whether it's for management or the union, is engaged regularly during the sessions in helping to persuade the other side that its position is the correct one. Is the persuasion always effective? Absolutely not. But it is part of the process. Getting to an agreement is persuasion. And there's really just two things, or at least two things that I think about in terms of persuasion. One category, one bucket is the logic persuasion, right? Which is helping a union, in my perspective, from a management side, helping in a union to understand that its proposal on a particular topic is not logical, right? It doesn't follow through in the logic. So a proposal that might say, we need extra cleanup time for all of the workers in the plant. And management comes back and says, well, absolutely, actually, there's this group and this group, they don't actually get dirty during the workplace. They don't during the workday. Why would they need cleanup time? So you're addressing their proposals with logic. And then finally, the other thing that I think is really helpful, and this often comes early on in preparations, is a data-driven, we're back to the math again, of course, is a data-driven analysis. So we are developing reports. We work with our paralegals, we work with others outside organizations to get the information that we feel is necessary. So data, for example, very often deals with comparables, right? What do other workers in the same industry, in the same line of work or the same geographical area, what are they making in terms of their weekly wages, or what are they making or what are their health insurance benefits are? All of that data is something we develop ahead of time. And to be honest, unions do the same thing. They're working to develop their data too. So if you go in there and you're not prepared with enough data, you feel shorthanded there. So anyway, those are the three things that I really just wanted to try to hit in terms of collective bargaining. There's obviously a great deal more. Those who've been engaged in it for a long time can attest to that. But obviously, if you have any questions about collective bargaining, certainly email or call me or any bond attorney. Thanks, Adam.
Colin, thanks so much. That's very helpful. Hopefully we can dive into that topic in a little more detail in follow-up presentations. But that's a great overview of the topic. Thank you.
You bet.
All right. Next up is Brad Hoppy. Brad is a member in our Buffalo office, and Brad is here to talk to us about the FTC's proposed non-compete ban. We had a presentation about it a month or so ago when it first came out, but after time to reflect, Brad has really dove into the proposed rule and is here to talk about some exceptions to that ban. So Brad, welcome.
Thank you, Adam. And for all of you who don't know anything about me, haven't heard me speak before, this is kind of what I do. I'm a non-compete lawyer. I draft non-competes, I revise them, I litigate them. So this is something that I've been following very closely, starting in July of 2021 with President Biden's executive order, and obviously through this proposed rule by the FTC. So I'll be chatting with you today about exceptions to the FTC's proposed non-compete ban. But I think before we talk about the exceptions, let's chat a little bit about the proposed rule itself. Next slide, please, Kathy. The origin of this proposed rule is President Biden's July 2021 executive order. It was a sweeping executive order that addressed all things that would, I guess, constitute or could be characterized as unfair competitive activities. One of the parts of that executive order relates to non-compete agreements. And the executive order used language that I don't think anyone really at the time would have construed as any kind of ban or prohibition on non-competes. The language, and I have it here in the slide, it encouraged the FTC to curtail the unfair use of non-competes and related covenants. There wasn't, any language in there, the use of the word ban. You didn't see that anywhere. You didn't see the use of the word prohibition anywhere. The assumption, I think, by most followers at that time was that, the FTC would do something similar to what a lot of state legislatures have done, which is, prohibit the use of non-competes for low-wage workers or something of like effect. And I think as most of you know, most states, New York included, they enforce non-competes when reasonable in scope and no broader than necessary to protect legitimate interests. So it did come as quite a shock when the FTC released its proposed rule in January of 2023. Next slide, please, Kathy. And that rule was released on January 5th. the proposed rule, may go into effect as soon as March of 2023. Right now, we're in the middle of the mandatory 60-day comment period. During this time, anyone can comment on the proposed rule, whether you're an individual that's affected by non-competes or a business that utilizes them, or a trade group or anything. So right now we're in that period of time, and based on those comments, the FTC very well may amend the proposed rule to address some of those comments, or they could vote on a final regulation as early as March of 2023, which is the end of that 60-day comment period. The proposed rule goes much further than what the executive order envisioned. It doesn't, seek to curtail only the unfair use of non-competes. Rather, it declares that all non-compete agreements involving workers constitute an unfair method of competition. The proposed rule defines worker very broadly to include not only employees, but also independent contractors, interns, volunteers, apprentices, and others. So pretty much anyone that provides a service for your company, would be a worker under this proposed rule. In addition, the rule prohibits the use of de facto non-competes. And a de facto non-compete under the rule is defined as any provision that has the effect of stopping competition. So the rule provides a few examples of what would be a de facto non-compete. And a de facto non-compete could be a very broad non-disclosure provision. Another example provided by the proposed rule is a financial penalty provision, one that requires an employee to pay back or reimburse the company for certain money spent. What the rule does say is that if it's tied to specific training costs or something of like effect, it's fine and it doesn't constitute a de facto non-compete. But if it's more of a penalty for leaving, then you run afoul of the proposed rule. And the final example, it's not really mentioned in the proposed rule, but I think it's one that you could expect to be a problem if this does go into effect, is your broad non-interference provision. Not just a regular non-solicit, but a non-interference that prohibits an employee from doing anything that interferes with the operations of the company. That would likely be a de facto non-compete under the rule. Next slide, please. All right, so we took a much deeper look at this proposed rule now that we've had a bit of time. And one thing that we discovered in our review and our additional research is that not all is as it appears when it comes to this proposed rule. And by that I mean the FTC has limited jurisdiction, so there's only so much the FTC can do. While on its face it appears that the non-compete ban applies to everyone, there are certain industries within the FTC Act that it very well may not apply to. So right here on the slide, I state the jurisdiction, what it says in the Act. The jurisdiction of the FTC is to prevent persons, partnerships, or corporations from using unfair methods of competition. The FTC Act expressly excludes certain industries from its jurisdiction. And those industries include banks, savings and loan institutions, federal credit unions, common carriers, and air carriers. So, notwithstanding, the breadth of the ban and what appears on the face of the proposed rule, these particular industries are outside its scope. Next slide, please. In addition, the FTC Act only applies to for-profit corporations and not true not-for-profits. Now, this is a gray area. It's fact specific. There's no test that's gonna you're gonna be able to say 100% whether you qualify or not. But the United States Supreme Court has stated the rule for whether you qualify as a true nonprofit, and that depends on whether the nonprofit uses and distributes its profits and whether it attempts to use nonprofit status for the benefit of others seeking monetary gain. I mean, obviously that's a mouthful. There's a lot that goes into that particular test. But certainly there are going to be some nonprofits out there that are exempt from this rule. And some examples, and again, it's going to be fact specific whether it applies or not. But some examples of nonprofits that may be exempt from the proposed rule include hospitals, museums, charities, volunteer service organizations, and research institutions. So, I mean, when you take these not-for-profits and you add in the exempt industries like banks and a few others, you start to see that, that this ban may not be as broad and apply to as many industries as originally thought. Next slide, please. So what does this mean for exempt organizations? It doesn't mean that your non-competes are automatically valid now. You still need to comply with applicable state law, whether that's New York or any other state. Here's the rule for New York State. A non-compete is enforceable if it's reasonable in time and geographic scope, if it's no broader than necessary to protect a legitimate interest under the law. In New York, that's confidential and trade secret information. It's customer relationships and goodwill. And it's also competition from a very small class of what's called unique or key employees. The non-compete cannot impose an undue burden on employees, and it cannot violate public policy. That's the standard everyone's been operating under for a very long period of time. And if you're an exempt organization, that is going to be the standard that you still need to comply with on a going forward basis. Now, if you're not an exempt organization and this rule does apply to you, there are steps you need to be taking now. Like I said, we are in the middle of the comment period right now. The rule is not in effect. But if it does go into effect, there are significant and very onerous notice obligations, not only for your existing employees who are subject to non-competes, but also your former employees that may still be subject to non-competes. There's very specific language that you have to include in your notice. And it's something you got to do in a pretty quick period of time once this goes into effect. So I think you need a game plan now. You do need to start identifying those employees who are subject to non-competes, both current and former. So at least you could be in the best position possible if and when this goes into effect. And I say if, for a couple of reasons. The first being, this rule may change significantly between now and the final rule based on the public comment period. And secondly, even if it does go into effect, I fully anticipate several legal challenges to this non-compete ban. And we'll see where they ultimately go. But I would anticipate that there's going to be challenges in friendly jurisdictions seeking to stay at the enforcement of this ban. So, that's something that we're, obviously going to continue to monitor. When, updates are necessary, we will provide them. I guess with that, that's all I have on this particular subject. But certainly, if you have any more questions or any questions at all, feel free to reach out to me at any point in time, or anyone at Bond who handles these kinds of issues. Thank you.
Brad, thanks so much. And I will plug Brad's blog piece that he wrote for the Bond Schoeneck King blog, which goes through some of this stuff in detail. So if you have any questions, you can consult the blog, or please reach directly out to Brad. All right. Last but not least, I'm going to be giving some updates on COVID-19. I don't think we've done a thorough update in a little bit. So with some recent changes, we thought it would be helpful to go through where we are now. Next slide, please, Kathy. So here's our normal Tuesday webinar data. You can see that cases have remained fairly stagnant in New York State over the past 90 days. A little bit of a downturn, which is good, but fairly consistent. 2,554 was the daily average of new cases yesterday, and that's 13 per 100,000 people. Again, these figures don't represent unreported cases. So to the extent people are testing positive and not reporting it, that they would not be reflected in this data. Next slide, please. The color of the New York State picture here is good, light yellow, not a lot of darker orange. We want to keep it light yellow, light orange, and that's what we've been for quite a while. You can see in the case numbers, cases have remained fairly stagnant. Again, not overwhelming numbers one way or the other. So this is all good news, and it leads into what we're going to talk about next. Next slide, please. All right, so where are we? I linked here to the current CDC guidance on isolation, which you can click on if you view the slides when we send them out over the next couple of days. The current CDC guidance requires isolation for 5 days following a positive test. You can end the isolation after 5 days if you've been fever-free for 24 hours and your symptoms are improving. The guidance also says that if symptoms are moderate, meaning shortness of breath or difficulty breathing, isolation should continue for 10 days. If symptoms are severe, meaning hospitalization, then in addition to a 10-day isolation, you should consult with your physician before terminating isolation. Regardless of when isolation ends, the CDC guidance requires or recommends that individuals who test positive wear a mask through the full 10-day period. Importantly, the CDC guidance does not have a quarantine requirement following exposure, although it does include recommendations regarding masking and testing, and I've linked to the CDC's exposure guidance on this page as well. I have a note up there, which is the important point that I didn't want to ignore, and that is that New York follows the CDC recommendations. So for a long time, New York had its own isolation and quarantine requirements. Those have gone away. We now follow the CDC guidance on isolation. There is no more quarantine requirement following exposure. So that's where we are in terms of what to do after you test positive or have an exposure. Next slide, please. COVID-19 paid leave. This is another topic that we frequently get asked about. Where are we now? Well, it's still here. And it's going to be in effect until the New York State Legislature says that it is not. So the amount of leave that an individual will receive is dependent upon the size of the employer. Remember that COVID paid leave now only results from a positive test and isolation, unless, according to the Department of Labor, an employer requires an employee to stay home following an exposure. According to the guidance at that point, the employer would have to continue to provide COVID leave unless and until the employee returns to work, is permitted to return to work, I should say. According to the DOL guidance, the second and third periods of COVID leave have to be based on a positive test. And then I put the quote in here, and the employee must submit documentation from a licensed medical provider or testing facility attesting that the employee has tested positive. Whether you as the employer require that proof or not is up to you, but this is what the guidance tells us to do. So the bottom line is COVID paid leave still in effect until the legislature tells us it's not. Next slide, please. Paid COVID vaccination time. This is again still in effect, although this particular statute has a sunset date and will expire on December 31st, 2023. So as of right now, employees have to get up to 4 hours of paid leave per injection, and that includes boosters. Vacation recovery time, there was a lot that the governor made about when this was first at issue, but the bottom line is an employee has to be able to use their sick time that companies otherwise have to provide in order to get in order to recover from symptoms related to vaccination. There's no special or additional leave. It would just be the employee's regular sick time. Next slide, please. All right, so recently we had a couple of developments from the federal and state government. At the end of January, President Biden announced that the national emergency declaration would likely be terminated as of May 11th, 2013. The White House press release stated that the president was extending the emergency declaration past March 1st, but that the president intended on terminating it as of May 11th. Now, what does this mean, practically speaking? Well, it has ramifications in terms of the government's payment for certain COVID-related medical expenses. So, for example, I know this having a large family, but you get 8 free COVID tests every month that have to be paid for by insurance. That's going to go away with the elimination of this national emergency declaration. In addition, there are changes to insurance reimbursement for COVID-related expenses. In conjunction with the federal national emergency declaration, insurance companies were required to provide payment for certain treatments and or testing related to COVID. We don't know exactly what's going to happen when this national emergency declaration is lifted, but the federal government and the White House has said that there will be a plan that they roll out before it is eliminated. So that's something to keep an eye on. Next slide, please. All right, just last week, New York State, the Department of Health issued a Dear Administrator letter, which I've linked to in the slide, which addressed face coverings in healthcare facilities. This Dear Administrator letter applies to all healthcare settings, including hospitals, nursing homes, home healthcare, physician's office, and dental offices. It was effective as of Sunday. And rather than requiring face coverings in all of these healthcare settings from now on, the state DOH is going to recommend that providers follow CDC guidance. It advises facilities to develop and implement policies for personnel and visitor masking based upon CDC guidance. So what the state is essentially doing is putting the ability to require masking back into the hands of the providers. Now, what this does not mean is that if you go to a hospital or a doctor's office, you don't have to wear a mask. Each facility will be authorized or is authorized under this Dear Administrator letter to come up with its own policy. I can tell you that here in Central New York, the major hospitals have indicated that they are not going to remove the masking requirement. So just because the state DOH has issued this Dear Administrator letter does not mean that all masking in hospitals and doctors' offices is going away. I would just recommend that you make sure you follow whatever it is that your provider is requiring. Next slide, please. Okay, a couple of final points. Last time I was on, I went through the healthcare vaccine mandate and the status of that mandate. We discussed the fact that there are competing decisions from trial courts in New York State about whether this vaccine mandate is enforceable or not. A Onondaga County Supreme Court justice held in early January that it was not. The state is appealing that decision, and the state filed a motion to stay the Onondaga County Supreme Court decision pending the appeal. We still don't have a decision out of the appellate court about whether or not that motion for a stay will be granted. So it's unclear. Right now, we're in hospitals, healthcare employers are in a waiting pattern, and we're waiting to see what happens with the appellate division, Fourth Department. At the same time, the CMS vaccine mandate still remains, which covers many healthcare employers in New York State. The only and significant difference between the CMS mandate and the New York State DOH mandate is that the DOH mandate does not provide for religious exemptions, whereas the CMS mandate does. So that's where we are in terms of the healthcare vaccine mandate. Next slide. Okay, so that's it. That's our COVID checkup, and that is our presentation for the day. Thank you all for being with us. If you have any questions, the contact information for everyone who presented today is on the screen, and we look forward to seeing you next week. Take care.